this all away someday, someday.
Hi, everyone. Welcome. Thank you so much for joining us today, and thank you to our wonderful presenters. My name is Deborah Chop, and I am thrilled to both be moderating this event and also attending this event. As some of you know, my oldest son, Jonah, is 18 years old, and even though my husband and I are both lawyers, we were caught completely unaware when that child turned 18, and all of a sudden, I had no access to his medical records. And though he acts like a child, I could not actually help him navigate the healthcare system. So it's really important to get this information. It is really important for parents to understand what changes when children reach the age of majority and to plan for it. So I, like you, look forward to learning tonight. And I want to let you know that our event tonight is sponsored by the Ann Arbor Jewish Community Foundation. The Jewish Community Foundation is the planned giving arm of the Jewish Federation of Greater Ann Arbor. It enables donors to create permanent endowment funds that address community needs in perpetuity. So the foundation has $10 million under professional management, including endowment funds for almost every Jewish communal organization in the county. The foundation exists to advance Jewish philanthropy so we can ensure an ongoing, vibrant Jewish community in this town. And through the foundation, people can make a difference, like you can make a difference during your lifetime, or by leaving a legacy gift that will help sustain the community through many years to come, through one of the foundation's planned giving vehicles or through Life and Legacy. My husband and I are participating in Life and Legacy so that we can continue to support the Ann Arbor Jewish community even after we are gone. And the foundation can handle all types of legacy giving. So the foundation is extremely proud to sponsor this event. It is committed to providing instruction on important issues that affect our community. We do a lot as Jews to usher our children through important life cycle events, from brises and baby namings to bar and bat mitzvahs to celebrations of weddings. Turning 18 is another significant life cycle event, and the foundation believes that our community is stronger when we have more knowledge. So let me introduce our panelists. We have three amazing panelists tonight. The first is Ed Goldman. He's an attorney who managed the University of Michigan Health System Legal Office for more than 30 years. He's been on the faculty at the University of Michigan Law School, the School of Public Health, LSNA, and he is currently a faculty member in the Medical School Department of Obstetrics and Gynecology, working on women's rights. In his spare time, Ed works with local not-for-profits like Our House, which helps foster youth transition out of foster care. He does yoga and he plays classical guitar. Lauren London serves as general counsel at Eastern Michigan University. She has practiced law in Michigan for more than 20 years and started at Eastern in November of 2013. Before her promotion to the general counsel position, she served as EMU's sole associate general counsel for 4 years. Lauren graduated from Brown University and she earned her law degree from the University of Wisconsin-Madison. And in her free time, does she have free time, one wonders? She serves as the executive director of the Penny Seats Theater Company, in Ann Arbor-based theater. She lives in Ann Arbor with her husband and 2 children, one of whom is on the cusp of turning 18. And then finally, we have Rebecca Leitman-Weidlinger, who is an attorney in private practice, specializing in Title IX in the institutional prevention of and response to gender-based discrimination, sexual harassment, and sexual violence. Rebecca's law practice includes conducting comprehensive Title IX compliance and systems reviews for educational communities, examining past responses to complaints of sexual misconduct, and providing recommendations for best practices in the field. Rebecca teaches and trains on school-related issues and sexual misconduct nationwide, including at the State University of New York's Student Conduct Institute, and the University of Michigan Law School, as well as in many other settings. Before entering private practice, Rebecca held in-house Title IX positions at 2 large research universities, and she was the former sex crimes prosecutor in Monroe County, Indiana. She received her JD from the Georgetown University Law Center, a master's degree in public policy and women's studies from the George Washington University, and her BA from McGill University. Friends, we are in very good hands. So I am going to turn this over to Ed, who is going to start us off.
Thanks, Deborah. We have divided this up. I am going to be talking about health-related issues, and for our purposes tonight, those really are powers of attorney, confidentiality, privacy issues, and health insurance issues. So why is this important? It comes as a shock to all parents that when their children turn 18, they're legal adults. And that means that we lose a substantial amount of our control over our children. The basic notion in Michigan and every other state is that a parent has a right to parent their child within reason, and the child has a right to grow up and become an adult. It is at the point of 18 when they become an adult. Now, does that mean they are independent? Not exactly. And the reason for that is the first thing I want to talk about, which is a legal notion called competency. For the law, in order to be competent, 2 things have to happen. You have to be old enough to be an adult, 18 in our state, and you have to understand the nature and the consequences of your actions. I tried to explain to my daughter that probably wouldn't happen until she was about 35. She didn't believe me then. She still doesn't believe me. So now I'm trying to explain it to my grandchildren. Competency is critical. If you are not competent, if you don't understand the nature and consequences of your actions, you cannot make decisions on your behalf. And that's why the first topic I want to talk about are powers of attorney. Let me just do a brief disclaimer on behalf of all the lawyers on the panel, which is, unfortunately, we get to talk about yucky stuff, not fun stuff. And one of the yucky things I need to talk about is what happens if something goes wrong? What happens if you're in the hospital? What happens if you're not competent? What happens if you're in an automobile accident? Who speaks for you? Well, before you were 18, your parents did. But as you heard Deborah say, once you turn 18, your parents no longer have access to your medical information. They are not your decision makers. Who is? You are. What if you can't? That's what durable powers of attorney are all about. Durable power of attorney is a lovely phrase. It also comes under the heading of advance directives, documents that you make in advance of something happening. None of those words mean what you think they mean. Durable does not mean it bounces when you throw it on the floor. Power doesn't mean power, and attorney doesn't mean attorney. A durable power of attorney is a document that you write before you become incompetent that takes effect after you are incompetent and that allows your rights to be exercised by somebody you name as your advocate. So durable starts after you're incompetent, power is right, and attorney is advocate. That means that the 18-year-old's got to write a document saying, this is what I would like, and this is who I would like to have decisions made for on my behalf if I cannot. How many 18-year-olds believe they are mortal? How many 18-year-olds think they need one of these documents? How many 18-year-olds go to school and, God forbid, something terrible happens? So, this turning 18 is not just an opportunity for presence, it's an opportunity to talk to your child about what it means to enter adulthood and what it means that they are now their decision maker and what can happen if they cannot make decisions. There's two flavors of powers of attorney. One is for financial matters. If your kid says, I'm going to be really busy in college, I don't want to take care of my savings account, I don't want to take care of my stocks and bonds, I don't want to take care of my college account, Mom or Dad, can you do that for me? You can sign your child can sign a financial power of attorney that allows somebody else to manage their financial affairs. What I'm really concentrating on is healthcare power of attorneys, which say, if I can't make a decision, Mom or Dad, Mom and Dad, older sister, whoever you want to name, over the age of 18, who is themselves competent, that's who I would like to make decisions for me. As an attorney in a hospital, I can tell you that I have seen terrible situations when people are in the hospital, are not competent because they've had a stroke or a car accident, and their family descends on the hospital. And what their family tells the healthcare professional is they dislike each other and they have differing opinions. Some of them say do everything, some of them say do nothing. And that's when we lawyers get called. That's when the social workers get called. That's when the ethics committee gets called. That's when courts might get involved. And you want to avoid that. And the way to avoid that is to have your 18-year-old adult sign a document that says what they would like. Now, they don't have to be specific. They don't have to say, if my temperature is over 104, then I want this. It is a general document. There are forms online. They are easy to find. And it is a critical discussion to have. I have had it with my daughter. I've had it with my two granddaughters, who are both over the age of 18. Each of them have said, can't we talk about something else? Then I say no, then we continue. And at some point they realize the importance of the conversation and why we are having it. So that's the first issue, advanced directives. Try the need to talk to your child about thinking about the unthinkable. The next area is titled HIPAA releases. Has nothing to do with your anatomy. HIPAA is a federal law, the Health Insurance Portability and Accountability Act, which at the end of 400 pages said, Congress ought to pass some confidentiality laws for doctors and patients. It's not clear to me why the people who wrote that law forgot that we had 400 years of doctor-patient confidentiality already, but they did. So they passed this law. They said, Congress, you should make rules. Congress didn't. So Health and Human Services did. They passed another 400-page document that talks about what you can do. One of my pet peeves about HIPAA is people don't know how to spell it. They spell it HIPPO. They spell it HIPPA. If you learn nothing else today, it is HIPAA, and the two A's are a secret reference to Ann Arbor as the center of the world. Actually, when I was practicing, and somebody asked me once what the two A's stood for, I said, if you did HIPAA on a daily basis, the two A's stand for Alcoholics Anonymous, which is where you have to go when you try to read that statute. Nobody believed me, so I switched to the Ann Arbor description. What does HIPAA do? It codifies what we already knew. It says that there is doctor-patient confidentiality and that doctors should not tell any third parties anything about your health care except, and some of the exceptions are, except if you're planning to kill your next door neighbor, or except if you're a child abuser, or except if you're an elderly adult abuser. And you can see why the law would have those exceptions. You have to think about the law as a system that sets rules of conduct. A basic rule of conduct is if you say something to your lawyer, your doctor, your priest, they shouldn't tell anybody else. And then what happens is we say, but what if? What if what they tell you is so terrible that you have to stop a crime? So forget about that part, and let's just talk about confidentiality. Confidentiality says a doctor should not tell any third party about their patient. Well, if the patient is your 18-year-old and your 18-year-old is suicidal and it's 2 weeks before Christmas and they're coming home for vacation, wouldn't it be nice if your doctor could say to you, you know, you should probably do some careful work and watch your kid when he or she is home? Well, they can't. They can't tell you that. As Deborah said at the very beginning, she has lost the right to learn about her child's health care. What do you do about that? You can write a HIPAA waiver. Your child can write a document that says, it's okay with me if you tell my parents about my health care. You will hear more about waivers later when we talk about FERPA, but just remember, what we are saying here is once your child becomes an adult, they have rights, you lose rights. If your child wants you to still have those rights, that's doable. And it's doable through a document that is a very simple document. You do not need to hire a lawyer to write these documents. They're pretty straightforward. There are templates online that you can find. But you have to ask and you have to have a difficult conversation. Now, the last thing that I'm supposed to talk about is health insurance. Health insurance is really pretty straightforward. Your child can stay on your health insurance plan until they are 26 years old. That is typically advantageous, but your child might be at a university that has a very good health insurance plan, and it might be better for your child to move to that plan. Or they may have a very well-paying job that provides benefits, including health insurance. This is a simple process. You simply say the default is once they turn 18, they can still stay on my insurance policy till they're 26, unless they have a better deal. And that's really what you need to understand about health insurance. Because I talked faster than I probably should have, I have finished my topic even before my time is up, and I am glad to relinquish my time to the distinguished senator. No, that's different. To Rebecca.
Lauren is going
Or to Lauren, sorry.
That was wonderful. Thank you very much, Ed. So I'm going to actually pick up the thread exactly where Ed left off, which is more in the vein of rights that you give up as a parent when your child turns 18. This is so FERPA, which you may or may not have heard of. It's a statute that I work with every day at the university, and it specifically regards who gets to control your child's academic information. And the operative term here is education record, and we'll talk a little bit about what that means. But this is very much another area where up until the child was 18 years old and they were going through K through 12 education, FERPA, the same statute, provided you as a parent of a student under 18 the right to review your child's education records and to give consent to access and to release the records in the absence of any kind of exemption. At the university level, you as the parent give up that right entirely, and it transfers almost entirely. And it transfers to your child, even if the child is not yet 18. What is operative here is that this person is a student at the university, and so once they matriculate as a student at the university, FERPA applies to them. So taking a step back, what is FERPA? So FERPA. The acronym is the Family Educational Rights and Privacy Act. It's a federal statute that governs the privacy of student education records. And the Department of Education has actually tied federal funding to institutes of higher education's compliance with this law. They always kind of wave the stick that if a university, whether it means, makes a policy or practice of revealing information in violation of FERPA, it can have its federal funds stripped. It's never happened. Ed or Rebecca can correct me. I don't know of a single case where a university has ever actually suffered a stripping of its federal funding for violation of FERPA, because usually what happens is the university is made aware that it is not in compliance with FERPA, and it immediately strives to correct it, and does so with that stick sort of hanging over its head. It remains a federal statute that is enforced. And so the main areas that FERPA covers are that students, when they graduate, when they attain the rank of a student, now have the right to control the disclosure of their own education records, the right to inspect and review their education records, and the right to seek amendment of those records. So we'll go through those briefly here. First of all, what is an education record? An education record, as defined in the statute, is a record that is directly related to a student that is maintained by an educational institution or by somebody acting as the agent of that institution. So what's a record? A record is any information that is recorded in any way, and be it written down, be it on video, be it a CD if they have those anymore, or in any way. But a record is not to be confused with knowledge. If the only place where something is recorded is in someone's brain, that is knowledge. That is not a record. It has to exist in some form, whether it's digital or written or whatever. And so that is a record that is directly related to the student. Directly related means, and I'm going to consult the statute here, personally identifiable information. Your name, your parents' name, your address, social security number, biometric record, date of birth, your mom's maiden name, or etc. It also includes any information that would allow a reasonable person to identify the student. So for example, if there was a release that said that something had happened on the second floor of Sellers Hall in room 204. Well, there's a large population who would know who lives in that particular room and would be able to identify the student in that way. So that kind of information would be information that's directly related to a student. A student is actually someone who is or has been in attendance at the school. It does not include an applicant to a school. That's actually that's a question that my office gets often. My students, applied and has had something happen, and can I ask for these records, et cetera. So FERPA does not apply to applicants. It attaches once the student matriculates the school. And it applies to records that are maintained by the school. Maintained is kind of a squishy term. It's not really defined, but suffice it to say that more records nowadays fall under the umbrella of records that are maintained by a school than outside that umbrella. There does not really have to be a showing that the university keeps a file of whatever kind of information this is in order for it to have been deemed to be maintained by the university. As long as somebody has a record of it somewhere, say an email chain back and forth, that could be deemed subject to FERPA. There are a couple classes of documents that fall outside the ambit of FERPA that are not deemed to be education records. I'll go through those really quickly. Those are sole possession records that are created by one person and just used as a memory aid that were never, meant to be shown to anybody else. Law enforcement records that are created, maintained by our Department of Public Safety. Employment records, and by this I mean not records that are maintained about a student doing a student job on campus, but really the reverse. If you have an employee on campus who every once in a while is taking a class, then the employment has nothing to do with that person's status as a student. And that person's employment records are separate from their student records and aren't considered to be, if that makes sense, aren't considered to be subject to FERPA. And then treatment records, as Ed was saying, fall under a different category. And then alumni records that were created or maintained after the student has already graduated. So what does FERPA allow in terms of disclosure? Chiefly, the main purpose is that students get to control who sees their records, how they are disclosed, and to whom. So usually what that means, the default is that you need a student's consent in order to give education records to someone. And students can give, as Ed was saying, a written consent that identifies the record and the purpose of the disclosure and to whom it should be disclosed. And just as in the case of medical records, there are online forms for these. They're very easy to do. You can even, they can do it by email. They can address an email to the record custodian, identify what records they want sent to whom and for what purpose. But there are several circumstances in which a school can send records identifying a student without the student's consent. And I'm going to tick through those a little bit because it's important to understand why some records might be released without the student's consent in advance. First and foremost, these are the ones that come up all the time, something called directory information. Directory information is very basic information about a student. Usually it involves their name, their campus address, or campus phone. I don't know if they even still have campus phones, but it used to be, if you had a campus phone, that was part of the directory information. Your major, the year that you're going to graduate, whether or not you participate in a sport, and some other kind of biometric information about student athletes can also be considered directory information. Every school defines somewhere on its website what it considers to be, and they say it publicly, what it considers to be directory information. And what they're saying by defining that is, we are going to just put a stake in the ground and say we can tell this information to anyone. And if you don't want us to share that very basic information, you may opt out of the directory. And any university will or is required to honor that opt-out wish. And we publicize the right to opt out every year. And so you can always make the decision to opt out of the directory. If you don't opt out of the directory, then that information about you is considered to be directory information. So the schools don't need consent to disclose it. They can also disclose it amongst each other to other school officials who have a legitimate educational interest. If they're just doing their job, they're trying to sign you up. It's the registrar. They're trying to sign you up for this class or that class or whatever. Their job requires them to know this information. That's not considered to require any student permission. Other universities, if the student wants to switch universities and enroll in a different place, we do not require permission before that. If a student themselves requests a copy of the information, you'll have to ask the student's own approval. And here's one we get a lot. Parents of a student where the student is considered a dependent for tax purposes. However, so everybody on the call could be saying, well, that's great, that's me. I claim my student, my kid is a dependent. I should be able to have whatever without, I can just go around the student. There are two reasons why that's not true. One is the university annoyingly will always require you to submit your tax return showing that they are in fact your dependent. And a lot of parents don't feel comfortable doing that in this context, when in fact they could just ask the student for a FERPA waiver instead. And two, again, it is up to the university to determine in its own discretion whether or not these documents fall, or whether or not to use these exemptions. It is up to the university. You can't, as a parent, force the university to disclose something to you without the student's consent because you think it falls within one of these exemptions. It's the university's prerogative to make that determination. There is, as Ed was referencing, there's a health and safety exemption to FERPA. If we believe a student is an imminent danger to themselves or to others, we can make an exception, and we frequently do, particularly because this is like a financial statute that has to do with university funding. If there's a darn good reason why very important people need to understand there's a safety issue going on with a student, we will go ahead and release that information. And then there are some disciplinary proceeding exemptions as well. So where a student, for example, has been accused of a crime of violence or a non-forcible sex offense, Rebecca will talk more about these, but there are certain circumstances where even without permission, universities can release the results of a disciplinary hearing. The student under FERPA also has a right to review their records. Now, review doesn't mean have copies of necessarily. Again, in this day and age, I kind of feel like this part of the statute is getting a little bit long in the tooth because everybody's got a phone and you can just snap what you need to snap when you're reviewing. However, technically the statute gives students the right to inspect and review their education records. Universities don't have to provide them with copies, just the opportunity to review. However, if a student has made a request to review their records, the university can't destroy them while a request is pending, because that would be spoliation of evidence, among other things. However, students have to act within their limits. They don't automatically under FERPA have the right to review their parents' financial records. If they are not also the student's education records, they don't automatically have access to those records. Letters of recommendation. This doesn't come up often, but sometimes a student will decide after the fact that they really would rather not waive their right to see that letter of recommendation. They can't do that. Once they have, well, they can only do that in certain circumstances. They cannot renege on the waiver that they gave to a letter that was submitted, that where they say, I don't need to see this letter, and then the letter is submitted. They will not have a chance under FERPA to see that letter. They can change their minds and say, you know what, I'd really rather see these letters of recommendation, but only for letters that haven't come in yet, if that makes sense. And then finally, I referenced amendments to education records. And this is a far less exciting thing than it seems. This is not the place for your grade grievances or things like that, things that would significantly impact a child's educational future. Truly, this is for what I would call a scrivener's error, where a student believes that the record is actually factually inaccurate. There's something about the record that just doesn't track. That is, not the way, that there's a minor error essentially, and they just need to correct the record. And there is a process under FERPA that allows for that amendment. And that is typically what you see under the right to amendment under FERPA. Again, we advise students of all of the rights that I talked about. Universities are required to and do advise students of their FERPA rights at least annually. Often it's one of the first things that's addressed with students at orientation. It's often in the student handbook. I have yet to see a student handbook that doesn't mention this. And usually there's email notification, presuming that students check their email. So I think I have made up for Ed's quickness with my length. And so with that, I will turn things over to Rebecca.
Thanks, Lauren.
All right. Taking a turn to Title IX. Hold on to your hats, folks, because we're taking the conversation in a different direction, but something that continues with our theme of being something that I think parents will really benefit if they're aware of what Title IX is and how rights under Title IX and information regarding Title IX can really shape their students' experience at college. So I'm not just going to talk about what is relevant to kids who reach the age of 18. I'm speaking about something that relates to educational institutions. And really what I'm going to focus on is colleges and universities. Although what I'm going to talk about also relates to K through 12 schools, I'm going to focus on information you need to know if your kid is headed to post-secondary schooling, college, university, trade school, and et cetera. So what is this Title IX of which I speak? It's a federal law. It was enacted in 1972. And to summarize, it prohibits sex discrimination in education. And often when I talk about Title IX to folks for whom it's a new concept, what comes to mind is equity in athletics. Gender equity in athletics is often what we think about when people talk about Title IX. And you may all be thinking about that because this year we celebrated the 50th anniversary of Title IX, and many of those celebrations focused on the fantastic gains that we've seen in women's sport, girls and women's sports since 1972. Some people also think when I talk about Title IX about discrimination in admissions to colleges and universities, discrimination in tenure and promotion. But I'm going to talk about a different aspect of Title IX, which I think as you hear me talk, you'll realize is very much in the news these days, much more than gender equity in athletics. And that is sexual misconduct, which I'm going to use as an umbrella term for sexual harassment, sexual assault, dating and domestic violence, and stalking. So as Ed said, sometimes we have to talk about yucky things, and that's basically how I make a living. So that's all we'll be talking about from when the microphone's on me. So Title IX's prohibition on sex discrimination has been interpreted through court cases, through federal regulations, and through administrative guidance documents to require schools to address, to have systems to address sexual harassment, sexual assault, dating, domestic violence, and stalking. So that's how we get to that statute that prohibits sex discrimination in education to talking about sexual misconduct, because through these interpretive sources, we now know that sex discrimination is this big bucket of conduct that includes sexual harassment, sexual assault, dating and domestic violence, and stalking. And ultimately, what Title IX tells us is that schools have an obligation to have policies and procedures to address reports of sexual harassment, sexual assault, dating and domestic violence, and stalking. And I'm just going to call all of that sexual misconduct. So I don't have to keep repeating all those words. Schools must have, again, policies and procedures to address those reports and to ultimately have some processes in place to investigate and adjudicate reports of that kind of misconduct. Now, Title IX applies to all institutions, all educational institutions that get federal funding. And this essentially brings into its purview really almost all schools, colleges, universities that we're familiar with, even private schools, even religious schools, independent schools. All of those we get federal funding in one way or another, often through accepting students who have federally backed or federally funded loans, lunch programs, subsidized lunch programs, one way or the other. Almost every school, college, or university that you're aware of is subject to Title IX. Although, fun fact, there is a school, a college very close to us that is not subject to Title IX because it truly does not receive any federal funding. And Lauren's nodding her head because it's famous in our field, and it's Hillsdale College. So that's a fun fact you've learned from my presentation. If you were sleeping before, you woke up because you learned that Hillsdale College actually is not subject to Title IX. Other than that, really every other school that you're familiar with is. So as a result of this, schools, as a result of this being Title IX's interpretation as requiring these policies and procedures to address sexual misconduct, really every college and university that I'm familiar with has an established Title IX office. It may be called the Office for Institutional Equity. It may be called the Equity Office, but some name like that. Every college and university I'm familiar with has such an office to deal with reports of sexual misconduct. And there's a lot that can be said about Title IX, but what I'm going to focus on for the rest of my portion of presenting to you, and of course, I'll be like everybody else, I'll be glad to answer questions, is what I think parents of kids going to college, what are the main things that you should know about Title IX? That's kind of what I'm using here as my guardrails up here. So first of all, I think you should know that anything going on at a school related to sexual misconduct is completely separate from the criminal police, prosecutor, and courts. So an act of sexual misconduct that may occur in a dorm, for example, an allegation of sexual assault, could give rise certainly to a police report and a criminal investigation and possibly charges by the prosecutor. And it could give rise to a school investigation under Title IX and a school adjudication of that, or that act could give rise to both of them at the same time or neither of them. Title IX and the school process for dealing with sexual misconduct is completely separate from the criminal system. Those two systems can exist on the same matter simultaneously, or you can have one or the other, depending on where the person harmed reports their conduct to, but they are separate. So that's something important to know about. I think right up there in terms of key things to know about are the support resources that are available that schools must provide to students who have experienced sexual misconduct. I really think this is key. We focus a lot in my field on the process for investigating and adjudicating, but first and foremost, Title IX requires schools to provide a variety of really important supportive measures to individuals who may have experienced sexual misconduct. And I hate to even let our brain go there, but if you have a student who's experienced sexual misconduct, that even if they never report it to the police or never report it to the school to be investigated or adjudicated, they have a right to supportive measures from their college or university. And those supportive measures are huge. They could be providing extensions of time to submit papers, get to taking an incomplete in a class that won't hurt their grades so they can make up for it when they're feeling better and have recovered. counseling, they can get to the, a lot of counseling centers are really burdened. They can bump to the front of the line at a counseling center if they've experienced sexual misconduct. That can be a supportive measure. Changes in all sorts of scheduling. They can get a change in their housing from one dorm to another. All sorts of supportive measures that students are entitled to if they have experienced sexual misconduct. And I think that's really important to know. In the field that I'm in, I often get people who call me under very sad circumstances and say, my friend's daughter is having this experience. My friend's son is having this experience. I actually just had that. And they did not want to participate in any sort of formal investigation. I said, they don't have to, but I hear this person is struggling. Go to this office. I was familiar with the office. They can, it's such a stressful time right now. People are coming up on finals and stuff. They can get some relief from that. The professors can be notified, not that the person experienced sexual misconduct, but they need some extra time. So there's wonderful supportive resources that are available to students through the Title IX or Equity Office. I think parents should also know that their schools have those. When I say school, I'm really referring to college, university, or school, that the schools have these policies and procedures. And you might want to take a look at them and have your student take a look at them. You're not going to memorize it. Some of them are 40 pages, I'm telling you. And some are shorter. But just to know that they're there. To know how to report sexual misconduct. Most schools have a very prominent way of reporting right on their website these days. But to be familiar and just have your kid know there are systems at this school for addressing sexual misconduct. I work in a lot of cases. I do investigations, and sometimes it gets to the school, 10 months after the incident occurred. That's not uncommon at all, many, many months after. And many people, students share, I didn't realize this was separate from the police. I thought that was my only option until I learned about this, a year after I started at this school. And so it occurred to me that even all the efforts that schools do go to educate the students about their Title IX office or equity office, these students, we know them. I've got two of my own who are in college right now. Their heads in the clouds. They're not listening to half of, probably 80% of what we say, at least of what I say. But I think it is important that you as parents try and remember that these policies and procedures exist and make reference to that for your students. So they're not left with a lack of knowledge about what can be there for reporting options or help options. And finally, I think, yes, this is my final thing. Of what I think you should know. I think that this is kind of in the manner of generating relationship and conversation between you and your student. Because we all know how much fun it is to talk to our teenage kids about sex, and then certainly sexual misconduct is even more fun than talking to your teenage kid about sex, of course. But I think it's important. I want to encourage you to take a look at your school's definition of what conduct is prohibited and what the definition of consent is in sexual encounters. And just to have not X-rated, I promise you it's going to be online, whatever school your kid goes to, I promise you in their Title IX or sexual misconduct policy, they have a definition of consent. And if you just have a conversation with your kid about, this is the expectation of your school, and just, hey, kids, something for you to think about if you're doing that. It's often an expectation that the individuals involved in sexual activity are communicating through mutually understandable words or actions, agreement to engage in a specific sex act. That's a pretty common definition of consent. And if you just kind of let that sink into your kid for a minute and then maybe talk about, so mutually understandable words or actions, how do you think consumption of alcohol might impact that? Your ability to understand what someone's saying to you, your ability to communicate what you want and don't want. And you could really generate a pretty meaningful conversation. And although we know our kids aren't listening to perhaps 80% of what we say, we also know it does land somewhere up there, I think, and it lands, and sometimes it even, plants roots. They're not going to admit it, but sometimes we do say something that's pretty worthwhile. And I think a conversation about consent and the starting point can be, hey, you're going to this school. Why don't we hop online and just check out what that definition of consent could be a pretty fruitful conversation. So I think I'll end with that suggestion for conversation with your kid.
Thank you so much, Rebecca, and thank you, Ed, and thank you, Lauren. This is incredibly informative and helpful. I'll just ask the first question while everybody in our audience is thinking of their own questions. Do any of you want to comment on how you see these topics through a Jewish lens? Like, why are we talking about them here?
Yeah, so I can start that. The privacy issue is completely in sync with Jewish law that talks about standing prohibitions against sharing anything revealed in a private conversation. So that seems to be perfectly consistent. And when you dig into that a little deeper, Jewish law says, yes, you should not reveal anything that you find out in a private conversation, except for the sanctity of life. And it's what Lauren and I both talked about. Everything's private except if a third party is in imminent danger of being hurt. So that's consistent in Jewish law. The other thing that's consistent in Jewish law is parental rights are always balanced against what is called best interest of the child. This is consistent with Michigan and every other state's laws. Parents have a right to parent, but they don't have a right to injure their child. Jewish law says the same thing. Parents have a right to parent, but they can't do it in a way that damages the best interest of the child. And Jewish law does one other thing that's very interesting. It says there's really deep respect for the individual, but also you have to consider the community. That's a little different from the American law approach of absolute autonomy. It says, yeah, autonomy is very important, but it's not the be all and end all. Under Jewish law, there's also an important notion of how do we heal the community? How do we improve the community? So those are the couple of things I found when I was looking at the Jewish law question. I want to say one other quick thing that I should have said earlier, which is when you're doing a document where you're naming an advocate, it's a really good idea to tell that person that they've been named as advocate. The worst thing in the world is to have somebody say, I'm the what? She did who? So, if you're going to name somebody as an advocate, especially if it's going to be your older sister or not your parents, there's a conversation you need to have.
Well, and I'll just pick up on that thread, Ed. The other Jewish concept that was just sort of rolling around in my brain for all three of us as we were talking about this is the concept of Lador Vador. I mean, we are standing on the precipice here of sending our children off into the world and giving them adult responsibilities. The world sees fit to give them adult responsibilities, and we respect that, and we honor it, and we celebrate it. And having these really, the conversations that both Ed and Rebecca referenced, I think are really difficult conversations to have. They're adult conversations, but I think Judaism celebrates the turning of the wheel and graduating into adult sensibility. These are adult conversations to have, and so I think that's kind of the tie-in. And we're all, as parents, as Jewish parents, at least many of the Jewish parents that I know, including myself, we are all control freaks. We very much want to help guide our children. And I feel that every day with my daughter right now. And I can feel her pulling away, and it's fine. And I'll be fine. But it is something to be celebrated. And I think that's the moment that we're all kind of at right now.
Deborah, let me ask Lauren one of the questions that I know she gets and that I got for years, which is under HIPAA, under FERPA confidentiality. So a child goes to the hospital. It's because they drank too much. They don't want their parents to know, but they are still on their parents' insurance. And a month later, their parent gets a bill and they call up Blue Cross and they say, hey, what's this bill for? How do you deal with that, Lauren?
It's extremely difficult. I mean, a lot of times, and it's very situation specific, right? I mean, again, sometimes it behooves the institution, and by institution, I just mean the college, the university. It behooves the institution to be forthright when we believe, to go ahead and share information when we believe that there's been a safety issue. However, more often than not, and I think this is what you were getting at, more often than not, you deal with the consequences and have to protect the privacy interest that was at stake in the first place. That is so hard to tell a parent. It is so hard to tell a parent who is upset and views this as their absolute right, where they absolutely have assume that they have the very best interest of their child at heart and want nothing more than to help their child. And the law is very much on the side of treating the child as an adult. And if there isn't a plan, such as you might have described, in a situation that you might have described for a waiver or a power of attorney or something like that, then that situation is really hard to deal with. And we sort of have to guide the parents through it. And they don't always love it.
Thank you. We are scheduled to run until 8:30, so we have plenty of time for questions if anybody has any questions.
Popping off Lauren's idea with the medical power attorney, and Ed, you had mentioned these forms are available on website. Are there particular websites you would recommend, like the Michigan.gov website for us, or any particular website you'd recommend, Ed?
There are several. The State Bar has a very good website, as does the State Medical Society. Actually, the Durable Power of Attorney was jointly drafted by the Medical Society and the State Bar. So that's where I would go first.
Alan, I see you have your hand up.
Yeah, Ed, something that also needs to be dealt with is their electronic footprint. This is not only for your 18-year-old, but also for your spouse, whatever. Could you talk a little bit about that new Michigan law related to access to your electronic footprint?
Well, tell people what you're talking about, Alan.
In your estate, you cannot, unless you've given direct permission, your spouse does not have access to your electronic footprint. Your bank records, if your joint account is one thing, but the rest of the things you keep on your computer, they need to have specific permission to have access to your electronic footprint. And most of our materials today are on our computers.
Yeah, so what Alan's talking about is broader than what we're talking about tonight, but oftentimes you have material, bank material, hospital material. Those of you who use St. Joe's or U of M know that there's a portal that has your medical information on it. And you need to give specific permission to a third party, including your spouse, before they can have access to that information. It's no different than what we've been talking about so far. You have to be aware of what information is out there. You have to be aware that it is information that is controlled so that only the owner of the information has access, but the owner of the information can provide access to a third party should they wish to.
Thank you.
Other questions? And I can't see everyone, so feel free to speak up if you have a question.
Carol. I see Carol's hand.
Oh, Carol, go ahead. I'm sorry.
Hi. This is very unusual. I am, my grandson is pretty much estranged from definitely from his mom and also from my son. So that's why I'm on this call. So Ed mentioned definitely tell the people who will be given the power of attorney, which it would be me. But to tell for my grandson to tell his father would be very difficult, as you can imagine.
Yeah, he doesn't have to. He has named you. He needs to tell you that you are the advocate. That's the legal answer. The familial answer is somebody's got to talk to your kids, and it may have to be you, Carol, if your grandson doesn't want to do it. But what you want to avoid is, God forbid, your grandson's in the hospital, not competent. Parents find out about it. They rush to the hospital, only to find out that they have no legal rights, but you do. That you don't want to wait till that happens. You want to try to have the conversation in advance.
Is there a way to tell the university to put that on the record?
Yes. Yeah, you can. You in fact, you can and probably should put that durable power of attorney for healthcare in the record of the hospital and in the university's record. And Lauren can talk more about how to do that. But at least at University of Michigan, there's a way to preserve those records so that they know who to call if something happens.
Yes, I'll just chime in and say, every university is different. Every place is going to have a different way of reporting that information, but all institutions of higher education are going to want to know that information. And so whether it's updating students' records with the registrar or wherever it is.
With the registrar. Okay.
Definitely reach out to the university and have them update their records. And there are many, in fact, that have online portals for students to go ahead and update that information themselves. And so it could be as easy. It could be as easy as that. But most of the time, if you have a question and you want to call the registrar, I bet they'll have the answer.
Thank you very much.
And Gary, I see that Gary put a question in the chat and he asked, are these laws typical for out-of-state schools? How are they different?
They're not. FERPA is a federal law. HIPAA is a federal law. They may differ in the sense that, for example, Michigan says you have to have 2 witnesses on the durable power of attorney for healthcare. Maybe Utah says you have to have 1 witness. I don't know. But for the most part, they are very similar. It's just, you just have to be careful about what the rules are for how you execute them. There are some states that say 2 signatures. There are some states that say 2 notarized signatures. So the policy is the same. It's just the process might change a little bit from state to state.
And I think for
question?
myself, the 2 statutes we were talking about are federal statutes. And although, just as Ed was saying, although it might be that the procedures differ from state to state or federal circuit to federal circuit, the statutes and regulations are the same.
I have a question.
Sure.
So I have a question and I have a comment. So first of all, if we have already a power of attorney about the health and of our child, what do we do with it? Let's say we sign it. Do we need to give it to somebody or keep it with an attorney or show it to the hospital when we need to communicate with the hospital? How do they know that it's even his own signature of the child? I mean, they have no way to verify. So that's the question. What do we do with the paper? And a comment that I would like you to comment on is the totally different section, which is the financial and the education, because the child, for example, in my case, he just gave me his password for his bank and for his education and say, take care of it. And I don't need any paper written.
Okay, let me take the last one first. Yes, you do need a paper. The fact that he gave you the password means that you are imitating him. And what you need is a financial power of attorney so that if the bank ever asks questions, you can say, look, my son gave me this. In terms of the first part of your question, it's what we were talking about a minute ago. Having the paper is a good thing. Locking it up in your safe deposit box is a bad thing. You need it to get to the people who need to use it, which means most hospitals, in fact, the federal law about durable powers of attorney for healthcare says a hospital is required to ask you if you have a durable power. And if you say yes, they are required to ask you if you would like to give it to them so they can put it with your medical record. You don't have to, but it's a really good idea to do that. And as Lauren just said, there's a process through the registrar of every school that will keep those documents because the school needs to know about them as well.
Any other questions or any other comments from our panelists?
I have a comment if there's no other questions. I raised earlier the question of the suicidal child who is about to go home for Christmas break. Lauren alluded to this in her comments as well. And I raised it because I want you to consider what's right behind me. Things could be legal and could be ethical. Things could be legal but unethical. Things could be ethical but illegal. And one of the problems we have as attorneys, especially attorneys representing institutions, is if I get a phone call and I am told that there is a adult child in our psychiatric hospital who is going to be released because they are stable, but they have been suicidal in the past and they are going home for Christmas break, should the parents be told? Legally, the answer is no, you can't tell them. Ethically, the answer is, yeah, you better tell them. And so what I always advise is talk to the child and say, look, you are going to go home. You know what you've just gone through. Don't you want your parents to know? And at least have that conversation. If the kid says, I absolutely do not want my parents to know, I am going to go home and I'm going to kill myself, either you keep them institutionalized or then you have this very interesting problem where probably you tell the parents. Frankly, I've never had to litigate this case, but a closing argument that says, ladies and gentlemen of the jury, yes, we violated confidentiality, but only to save a life, I think is a pretty good closing argument. I don't know, Lauren, if you have thoughts.
I completely agree, Ed. That is, on a campus, our priority is always the safety of our students and the community. And so if there's ever a question, that safety could be in play, we would much rather violate FERPA, which, as I mentioned, there's never been a fine that has come out that has stripped federal funding from a university because of a violation of FERPA. I'd much rather violate that statute and keep everyone safe than the reverse.
Thank you. Any other questions?
Just a comment, Deborah. This has been an excellent program and sponsored by the Jewish Community Foundation. This will be put on the website of the foundation for people to go over it. You may want, those listening may want to tell their friends or peers that this was a helpful program and they might want to listen to it.
Thank you.
And thanks to Ben for organizing it.
I will turn it over to Ben.
I also have a
Oh,
comment.
go ahead, Susan.
I want to thank you all for attending. This has been an ongoing a program that we've wanted to have to educate people on the kinds of programs and the kinds of information that's needed for leading a planned life. We've had a couple of other programs which are on the website. And as a result of this, if there's anything that you think of that you would like the foundation to present, please let us know. We are a very active and committed group. And we once again thank you so much for joining.
Yeah, so on behalf of the Jewish Community Foundation and the Jewish Federation of Greater Ann Arbor, thank you so much for attending this event. Thank you to our wonderful panelists, Ed, Lauren, and Rebecca. Could not have done this without you. Thank you so much, Deborah, my fantastic co-host, for moderating this event and helping me organize everything. And then if you have any further questions about the Jewish Community Foundation, please reach out to Eileen Freed or Susan Fisher. If there are no final last questions, thank you again all for attending, and we will be sending out the recording soon.
I'm just going to add one more thing before everybody logs off. We've considered doing a program like this for the actual teenagers. I'm curious to know whether you think your kids would actually, I mean, we know it would be helpful for them to attend. Do you think we could get them to attend? Because that's something we're considering doing, trying to speak to the kids directly.
Maybe we'll ask that in our follow-up evaluation, and let us know if you don't want to say now. Oh, Stacy says if it lasts for 5 minutes.
Okay, these are all really good suggestions. All right, dancing, 5 minutes, BBYO.
And free food always helps with my
Free food, but no alcohol. Thank you, everyone. This has been a pleasure and super informative. Thank you.